I'm doing peace, love, bliss to everyone that comes in. I am going to get right into it. There will not be any playing around or anything this morning. If you do miss it, please rewind because it will be under members only shortly. Peace, love, and bliss to whoever comes in. Let's get right to it.
History of Title 46 Codification Efforts. The codification of Title 46 began with the enactment of Subtitle II, Vessels and Seamen by Public Law 98-89 in 1983.
Let's go. Why is this thing acting up? Okay. I don't know why it's hesitating, guys. Give me a minute because I definitely am not going to do all this reading today. Let's go. Acting real crazy.
Report text available as TXT, PDF, 1 megabyte. PDF provides a complete and accurate display of this text. Complete and accurate display. See the PDF in 108 to States Code.
It just went where it wanted to go.
Or referred to the House Committee on the Judiciary to accompany HR National Budget Office.
This thing acting crazy.
United States Code, preferably thereon with an.
I'm gonna have to read this because it's about to get on my nerves.
History of Title 4.
Let me see. Let me see if I can do the PDF form, if it'll do the same thing, because this is so annoying. Definitely want you guys to get this, okay? All right.
Report text available as TXT, PDF, 1 megabyte. PDF provides a complete and accurate display of this text. Formatting necessary for an accurate reading of this legislative text, for example, italics, strike-throughs, or bolded brackets indicating which text is to be added or omitted, may be missing from the TF 108 Congress Report, House of Representatives, Title 46, September 17, Mr. REPOR, including cost to whom was referred vacation of time, having constitute and
Why am I having issues today? Why? Just why?
3 committee.
Hold on, let me go back again because this is really retarded.
Budget office cost estimate.
Doing that, it's really retarded. Goodness gracious, all of that. Goodness. Shipping and positive law. I wanted to get into this with you guys, but I swear I'm not going to do all this reading. I'm doing a live this evening, a very important live on the young lady, part of a cult, and she's going to go through how she got to be in it and some of the things she went through and how some of these people are just doing too much. Okay, so let's try and start it right here. We're going to try one more time. I don't know why it's doing that, but usually don't even do that. If I'm listening and studying and listening for myself, it wouldn't even be doing that. But let's try it again. Let's see.
Report text available as TXT.
It's going to have to go
PDF, 1 megabyte. PDF provides a complete and accurate display of this text. Formatting necessary for an accurate reading of this legislative text, for example, italics, strike-throughs, or bolded brackets indicating which text is to be added or omitted, may be missing from the TXT display. For a complete and accurate display, see the PDF. 108 Congress Report, House of Representatives 2D Session 108 to
All right, here we
690.
go.
Codification of Title 46,
Codification,
United States Code,
Title 46,
Shipping as Positive Law.
positive
September
law.
17, 2004, referred to the House calendar and ordered to be printed. Mr. Sensenbrenner, from the Committee on the Judiciary, submitted the following report to accompany H.R. 4319, including cost estimate of the Congressional Budget Office. The Committee on the Judiciary, to whom was referred the Bill H.R. 4319, to complete the codification of Title 46, United States Code, Shipping, as positive law, having considered the same, reports favorably thereon with an amendment in the nature of a substitute, and recommends that the bill, as amended, do pass. Contents. Page the amendment to background to history of Title 46 codification efforts to conformity with original intent 3 hearings 3 committee consideration 3 vote of the committee 3 committee oversight findings 4 new budget authority and tax expenditures 4 Congressional Budget
Tax
Office cost
expenditure,
estimate 4 performance goals and objectives 5 constitutional authority statement 5 review and comments 5 disposition tables 15 section by section analysis and discussion 31 markup transcript 187. The amendment. The text of the amendment appears in italic type in the reported bill. Background. This bill is a joint product of the Department of Transportation and the Office of the Law Revision Council of the House of Representatives. On November 10, 2002, a Secretary of Transportation transmitted to Congress proposed legislation to complete the codification of Title 46.
I'm about to take y'all somewhere else because that's about to get on my nerves. And I do not feel like reading all that small writing right now. I'm gonna pull it up in another area. So give me a second. We'll just read it from the law. I really wanted it to just read the whole thing real quick, but obviously, we're not gonna have things to go all the way like we want sometimes, right? And I do not get disappointed. Okay, we're going to read Article 4, Section 1. When it comes to full faith and credit, I'm going to browse through quite a few things real quick. I hope you guys are able to take notes so that you can get your fundamental mentality up, right? So you can get your fund, F-U-N-D, funding a mental, getting your mental capacity together, not being feeble-minded, being able to operate efficiently in the light standing of law, right? So only if you're doing that, you're able to have a complete understanding or understanding of the things that I'm showing you. Everyone is not privy to this information. A lot of times when people hear things, they believe that they know or understand the actual laws when it comes to applying it to you and yourself, being an actual living man or a living woman, having nothing that has ordinance over you other than the Most High, God, whatever you want to, put the name on, there's a hierarchy of what actually holds the power over the people. And that is the person that actually has brought this to provision. So who has the control over your soul or your spirit or your energies that have come into this particular atmosphere? The control is given, right? Only if you know how to assume the control and take the efficiency of stable-minded thinking, right? Able to understand, and use things that are applicable to a person's lifestyle, right? Being that you are a consumer who has what? Full faith and credit. Now check this out. I've gone over this before, just to verify. Full faith and credit shall be given in each state, Now, that would mean each state as well, right? Each state being the 50 states that are sovereign to the United States that are not a part of the corporation or under its particular control. When it comes to it, right? When a person has the E state, there is the energy state, which is the transmitting utility. You being the operator, you being the currency, the actual current, the only energy that actually is allowed to give the current. Current is the present, right? Current, present, energy in the presence of a person that is able to use that for their own edification. So now if you're doing that, you will have a better enlightenment in your mind to see what is beneficial to you. Once again, full faith and credit shall be given in each state to the public public records, and the judicial proceedings of every other state. So full faith and credit shall be given to judicial proceedings. Anyone understand what that means? It should be given in what? Court cases? What is a judicial proceeding? Is that a court case? It is a court case, right? A judicial proceeding. And the Congress shall, by general laws, prescribe the manner in which such acts, records, and proceedings shall be provided and the effect thereof, right? After the full faith and credit clause ratification, jurors debated whether states only needed to accept out-of-state judgments, to accept the judgment as evidence in the judicial proceedings, or if they needed to give out-of-state judgments. If they needed to give out-of-state judgments, conclusive effect instead. The Supreme Court reached the latter conclusion in Miles versus Durhee. Look that up. Not Miles, I'm sorry. Mills versus Durhee. Holding the states ordinarily cannot re-examine an out-of-state judgment of merits. The court that is reasoned that if judgments of the state court were considered prima facie evidence only, the full faith and credit clause would be utterly unimportant and illusory, as the common law would give such judgments precisely the same effect. They said what? The common law gives those judgments precisely as the same effect of what? Receiving the full faith and credit via the prima facie evidence, right? Let's move on. Understanding under UCC code 3-601, right? What is discharge and the effect of a discharge, right? The obligation of a party. It just told you about the obligations. The obligation of a party to pay the instrument that is discharged as stated in this particular article, or by an act or an agreement with the party which would discharge on obligation to pay money under a simple contract, which would discharge an obligation. Discharging an obligation. Discharging the obligation of a party is not effective against a person acquiring rights of a holder in due course, and the instrument without notice of the discharge. What is the obligation of a party? A party is connected sanctions, right? So we're thinking about a contract, setting up a contract, going into applying the transmitting utility credit to the application. You are the person that is applying it. You are the creditor giving the credits to the particular application. So now, if you do not discharge, and there's an obligation that they have applied to you, and you do not discharge or take that for relief, then you are allowing them to basically assume that you don't understand, which you don't. Most people don't. That's why I try to put you on, but that it's not for everyone. So discharge of that, and I want you to understand what the party is, right? A party is a person that is, hold on, let me go up a little bit. Goodness gracious, I didn't want to go way up there. Hold on a second. A party. Party means a party to an instrument. What did I just tell you? The conjoining party. Let's hooray, hip hop hooray. Yes, I'm going to run your credit. Woo. Yeah, let's get it. So that's the party, right? A party means a party to an instrument. What did I just explain to you guys? What is an instrument? An instrument is a bill of exchange, a negotiable instrument, an application, a bill, your monthly bill. All these things are parties to an instrument. Who is the principal obligor? With respect to an instrument means that the accommodating party or any other party to the instrument against whom the secondary obligor has recourse under this article. The obligor has recourse because you can what? Discharge. I just showed you. It just told you that you can discharge being the principal obligor. The promise means, when it comes to a promissory note, means a written undertaking to pay money. And what did Congress say in 1933? There is no legal money other than gold and silver, right? All obligations and the obligor is the United States. All obligations belong to the United States. They have a fiduciary responsibility as long as you are handling things in your right perspective to discharge. Let's talk about the promise. The promise means a written undertaking to pay the money signed by the person, making a promissory note, undertaking to pay. An acknowledgement of an obligation by the obligor is not a promise unless the obligor also undertakes to pay the obligation. And you would do that by what? The discharge, or creating what? A negotiable instrument for payment that is legal tender. Proof that the respect to the fact means to meet the burden of establishing the fact. You can look under section 1-201B at 8. Reserved and the remitter. What is a remitter? Means a person who purchases an instrument from its issuer. A remitter. Who is a remitter? A person who purchases an instrument from its issuer. Would that be a real estate broker? Would that be a car dealership? Let's use those for example. So a remitter, the person that is purchasing, right? The remitter purchases the instrument. The instrument is what? The negotiable instrument, the bill of exchange that you created with your blockchain credit, applying your social credit, which is what? Your social security bond number, bonding the payment to this particular item. You are creating the bond. You are creating it and you are remitting it. You hear people say the remittance. That means you are the person that would be submitting this. You are the issuer, right? Just so you have a clear understanding of that. You are the issuer if the instrument is payable to an identified person other than the purchaser. Who is the issuer? You. You are the issuer, right? Let's go back. So when it comes to this, the person that is acquiring the rights, listen, it is not effective against a person that is acquiring the rights of the holder in due course of the instrument without notice of the discharge, a notice, sending an affidavit, a notice of discharge. Notice the principal, notice the agent, the notice to discharge. Okay? Let me check with the chat and see if anyone has come in or is asking a question. Or anything? No. Greetings, Audrey. Peace and bliss. All right. Now, check this out. Let's keep moving on. This is going to be real clear to you guys. I'm going to make it as clear as I can. You guys know I'm not doing a lot of information on this. I will be saving all of my utility, which is my current energy, for those that are in my courses. But I don't mind showing or sharing this information so that people understand. No matter what is being said, if you do not have an eye to see, an ear to hear, and the understanding in your heart, it will go right over your head. So it's not for you, right? Period. So let me get back to this because I'm going to be getting out here shortly. I want you guys to understand what illusory promise is, right? Illusory promise is a promise that is unenforceable. It is unenforceable due to the indefiniteness or the lack of mutuality. So that would mean what? A third-party creditor. So if I go to acquire a vehicle, right? I'm going to use a vehicle. That's the simplest thing. That or a home. If I go to purchase or acquire a vehicle, right, and I go and I apply the applicable credits, right, to the particular person that would be going into the contract with me, right? So we filled out the application. You know, we've looked at everything. I've signed it. I've agreed. I want to drive off with my vehicle today. Now, there's something that is an illusory promise, right? That promise would come from the third party. Well, this third party, you now have finances charges due to your credit, right? Well, if it was due to my credit, I shouldn't have any issues, but this is what they'll tell you. Due to your credit, right, there is an illusory promise attached to your contract. Now you have another binding contract with a third party. You have your notices to pay from the finance charges, these finance charges that you should not even be acquiring because all of the finance charges actually belong to you. But because you don't understand or understand equity, and you don't know that you have all rights, being the particular creditor who is issuing the credits, Having the application and creating that negotiable instrument, that bill of exchange, honoring that, right? Someone else attaching themselves, a third-party creditor, is an illusory promise where they're saying that you owe them, but you don't. You never do. Because if you are operating efficiently, you would be going in with your affidavit, noting and stating your terms. You have the right to the terms. When a contract is created between two people in agreement of what is fair, right? And it must be fair on both sides. So if I create a contract and it's not fair to me because you're putting that I owe you finance charges, I'm going to pay you X, Y, and Z each month, blah, 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 so on and so forth. If a person is not privy, right, to knowing how to handle those particular things, then they would be indebted, right? They would be indebted, but you don't have a debt, right? Your debt does what? Belong to the United States. All debts belong to the United States. I've showed you guys this many times. There should not be a question about that. So if someone says, hey, you have a debt, how can I owe a debt? There is no money. Since 1933, there has been no money. The only thing that is created is fiat currency. Fiat currency is what? A debt note. Debt notes are created so that there can be a promise of an illusory to a person to pay. You may not understand that, but let's keep moving. I don't want to stay on the one thing. So, as I told you, an illusory promise and the lack of mutualities, if it's not going to be on, let me read that to you guys real quick, just in case. Mutual assent. Listen to mutual assent. Mutual assent refers to an agreement by all parties to a contract. An agreement. I agree to these terms. I am setting the terms, and we both have to come into agreement with this. If you're setting terms on a contract that are not fair to me, that makes it illusory because you have held back some of the terms. Maybe not notifying me of my rights to rescind. Maybe not notifying me that I have already signed for this particular credit item because all items are prepaid through the United States government through their articles of participation and certificates of the articles of incorporation and their certificates of participation, so that they are able to, hold on a second, guys. Hold on a second. Give me 1 second, guys. Okay, sorry about that, guys. All right, so having an understanding of this. When it comes to the illusory, hold on 1 second, guys. All right, guys, give me 2 seconds. Sorry about that, guys. I had to talk to my baby real quick. All right, so hold on 1 second. Let's get back to it. All right, so when it comes to the illusory promise, you guys have a clear understanding of that, right? I think I went over. I want you guys to see mutual assent. When it comes to mutual assent, again, right? Mutual assent refers to an agreement by all parties to a contract. The mutual assent is an essential element. It is essential, which means that it has to be present. Do you guys understand that? Mutual assent means that it has to be present. It is an essential element in the formation of a valid contract. So that means what? If there's not mutual assent, if there's not an agreement by all parties to have a particular contract, right? Then that means that the what? The contract is what? Invalid, right? Because it says that it must have these elements in the formation of a valid contract. So if it does not have these elements, it is what? It is an invalid contract. Now, under modern contract law, mutual assent must be proven objectively. Thus, courts will look to the outward expression of the parties to determine the mutual assent, often established by showing an offer and an acceptance. An offer and acceptance. Didn't I just tell you? You make a mutual offer on your contract. It must be plausible to both parties. If it is not, then it is an invalid contract because there's no mutual assent. There is not any type of fairness in the contract. That also makes it invalid. Now, an offer to do X in exchange for Y, to do one thing in exchange for another, right? Following by an acceptance of that offer. So you must accept that offer. You must say, okay, I believe that this is a fair contract. I think that we are mutual in our agreement as to what's fair, the equability that we have in this, right? All of the equity that has occurred on this particular item that you have put in the finance charges, I think what would be fair based off of the law, 20% would go to the fiduciary or the trustee, the one that is creating the contract, the one that is offering the service, the one that is offering the product, right? So once they complete that, they are now giving you the ability to either contract with them or not. If you do, you must present your terms, right? In a contract, the terms have to be on both sides. So if you presented your terms and you guys have a mutual assent, because there is a 20% liability to the fiduciary, 80% of that equity would belong to you. Me, myself, I'd offer 30, 70 for me, 30 for them, so that you guys are able to get a fair, equitable account of what's going on. And I am able to use this to my perfect feasible interest. And now you guys can incur all of that interest. We've made a contract. We're going into this the correct way. Now you won't say that I have to pay or owe these finance charges because what? We have agreed that most of it belongs to me because it really does by all extents of the law. Let's go. Mutual assent is closely related to the concept of meeting of the minds, right? If we don't come into the meeting of the minds, we can't contract. If we don't agree and we don't find that we both have something that is understandable, we are not mutual in the contract. This, which requires that the parties to a contract agree to the same terms and conditions and the subject matter. That's very clear, right? You guys have a very clear understanding of that, I'm sure. Let's get into the waiver and a renunciation because of a breach, right? Now, when it comes to UCC code 1-306, the waiver of renunciation of claims or right after breach. This is subsection 1-306. It comes to waiver or renunciation of claim. Waiver, renunciation of claim or right after a breach. Your rights after a breach of contract, after a fraudulent contract with illusory promises, right? Now, a claim or right that is arising out of the alleged breach may be discharged in whole or in part without consideration by the agreement. Listen, a claim or right that is arising out of an alleged breach may be discharged in whole or in part without consideration by agreement of the aggrieved parties in an authenticated record. I will go over that with you guys, but that's a little bit too much. I don't want you guys to get too caught up in this, but I'm going to show you one other thing when it comes to the prima facie evidence by the third-party documents. This is subsection, this is section 1, subsection 307. A document, listen to this, a document is due in due form, right? Purporting to be a bill of lading. Listen, a document that is due form purporting to be a bill of lading, policy, or a certificate of insurance, official wires, or inspector certificates, counselor invoices, judgments, or any other document that is authorized or that is required by the contract to be issued by a third party is prima facie evidence of its own authenticity and genuineness and of the facts and stated in the document by the third party. So understanding that what a bill of lading is, just so you guys are clear on that. Hold on a second. A bill of lading. A bill of lading means a document that is evidencing the receipt of goods. A bill of lading. Do you mean a bill of exchange? Do you mean like a negotiable instrument? A bill of lading? Yeah. A bill of lading means a document that is evidencing the receipt of goods, right? For the shipment that is issued by a person. What is a person? We know that's a company, a corporation, a car dealership, a mortgage company, so on and so forth. By a person engaged in the business of transporting or forwarding goods, because all items are prepaid, based off the United States Constitution and based off of your consumer rights and your essential needs. All essential needs are provided by the United States. All that belongs to the United States since 1933 and Roosevelt's New Deal program. Right? Let's go back. I don't want to get into all the definitions because that could take all day, because especially for people understanding that. Acceptance under the reservation of rights, right? Make sure you guys understand it. Acceptance under the reservation of rights. A party that with explicit reservation of rights, with explicit reservation of rights, performs or promises performance or assents to performance in a manner demanded or offered by the other party, does not thereby prejudice the rights that are reserved, your rights that are reserved, the rights that are reserved that no one can ever change, because you always have the rights, right? You, the people, have the rights at all times. All right. Let's get to this real quick. This is kind of important as well. And actually, let me show you guys this real quick, because I want you to understand something when it comes to what we just shared, right? In every contract, right, you have a right to rescind. Didn't it just say that? It told you that you have a right to rescission of a contract. Anytime you have a large ticketed item, a home, a vehicle, anything, a business, facility that you're purchasing, any particular real estate, so on and so forth, a H-9 rescission form should be in that particular application. An H-9 rescission form should be in that particular application. Are you guys aware of a H-9 form? Lord, she got a baby. No, I don't got no baby. That's my grandbaby. That's my grandbaby. Peace, sis. Yeah, it's one of my little beloved. Okay, so 8-9 rescission model form is a new advance of money with the same creditor, a new advance of money with the same creditor, and your right to cancel this loan. This should be in every application for a large item. You have the right under federal law to cancel this new loan on or before the date that is stated below. This should be a rescission form, an H-9 rescission form should be in every mortgage, should be in every home purchase, should be in every utility purchase, so on and so forth. The right to rescind, the right to cancel. And it tells you right here what you would just cut this part off, send it back to them. Your name, the property of that address, what that loan number is, and rescission. Why don't they give you, oh, you know what? It's not even viewing. I'm sorry, guys. I apologize. Hold on. Here's the H-9 right here. Let me pull it up for you guys. All right, sorry guys, I thought I had switched the page. So the H-9 rescission form, as it says right here, right? Your right to cancel this loan. Your right to cancel this loan. Now, if they don't have this form in your application, that's immediate fraud. Did you know that? If they don't have it in your application, it's immediate fraud, not giving you your rights, because the people have the rights. If you do not have this in your application, it is immediately fraudulent, telling you that you are able to cancel. I am big bold letter that tells you, I am canceling this loan. You would put your name, the address of the property, and the loan number, right? That is so important in understanding that you have the right to rescind any and every contract. And when it comes to the rescission of the contract, right? Go to here. When it comes to the rescission of the particular contract, those contracts are non and void. You have the right to dispute, you have the right for rescission, and you have the right for remedy, remittance, right? Discharging the debt that was created, because they created the debt. You didn't create the debt. You provided the payment, the initial credit. And then they created the debt with the false contract. The creation of the false contract is what created or initiated the debt. When you go into the contract, you don't have a debt. You are the authorizer. You are the person that is applicable to applying the blockchain credit under your social credit system, right? That social credit system that was assigned to you at your birth. People do not understand or understand when it comes to equity in your law. Check out tender of payment. This is under UCC subsection 3-603. If a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, and the effect of the tender is governed by principles of law that are applicable to tender of payment under a simple contract, which we just kind of went over, if you have understanding, right? If tender of payment of an obligation to pay an instrument, tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, have a quick understanding. Y'all know what an instrument is, right? I've told you over and over again, but let's check it out just in case, right? There are many, many instruments, but let's talk about a few negotiable instruments. What is an instrument? Instrument means what? Instrument means what? A negotiable instrument. How many times have I told you guys about a negotiable instrument, right? It's an order that meets all the requirements of subsection A, except paragraph 1, and otherwise falls within the definition of a what? Check. A negotiable instrument is a what? A check, right? Of a check. And subsection F is a negotiable instrument and a check. Let me make sure y'all with me. Let me check with my chat real quick. Oh yeah, bro. Oh yeah, bro. Oh yeah. Now, if you already have your vehicle and you have not proposed a contract beforehand, I can definitely get you the information to get out of that, bro. I have a new class starting this Wednesday. Is the end of the 4-week course. We got a little sidetracked last month, so we kind of we got delayed a little bit, but the 4th week will be this Wednesday. So the next 4-week course will be starting next week. The next 4-week course will be starting next week. Let me put the information up here just in case anyone is interested. I don't know. Listen, I don't know what to tell you guys. I'm just here to try to help you, get you in the right space. No matter what is going on in YouTube avatar world, you guys need to be living in real life. Y'all need to really be paying attention to what's going on, right? Y'all need to be making sure that whatever you are doing, you know, I don't even know about this sistersoul.net. Now, the sister that set up this page for me, that sistersoul.net, she told me that, oh, you know, I got you for a whole year, sister. Now, after all this nonsense with these gossiping hens, the chick told me that I got to start paying. I get an invoice after you told me that my service was for a year that you offered me. I never inquired or requested it. You know, oh, I was told to do this and that. You know, people are so shady and weird. I'll just say that. I refuse. I'll start my own damn page. I don't need nobody telling me you doing something for me. And then when you hear some gossip and all this, oh, I love you, sis, and we connected, all that fake ass shit. I can't deal with it, y'all. I can't play with people. What is wrong with y'all nutty ass people in this community that do not know how to stick to your mental capacity, your own mind? Not going under the discernment of other people. The shit just made me sick. That's off topic, guys, but I just had to mention that. Oh, you got a service for a year. Then because of somebody's gossiping in info, because they're ignorant, don't know shit, probably got a 4th grade education, they want to listen to somebody else and sit up here and change or switch up on me. I don't do change ups and I don't do switch ups. I don't play with people. That's first off. I'm a woman of my word, you know, so everybody don't do the same thing. So keep that in mind. Y'all can't really focus on that that page. I just want you guys to know I am going to be changing that. When I get time, I'll just start a new page and do my own thing. I should know not to even depend on people because people are just so, I don't know. Yeah, let me put this one up. Okay. Reach out to my email because, I don't have time. I really don't. All right, guys, let's continue on. Now, a promise or an order, right, other than a check is not an instrument if at the time it is issued or first comes into possession of the holder, it contains a conspicuous statement. A conspicuous statement would be an illusory contract statement. That's what I call it because it's conspicuous. That means it's illusory. That means you don't really get it. It says, however, expressed to the effect that the promise or order is not negotiable or is not an instrument governed by this article. Now, an instrument is a note. Check this out. An instrument is a note. If it is a promise and is a draft, it is an order. What is an order? Given an order, that's instructions to do something and to comply. If an instrument falls within the definition of both a note and draft, a person is entitled to enforce the instrument, may treat it as either, which means what? I can treat it just like a check. That negotiable instrument, the contract, the application, the bill of exchange, we gonna get into too much else. The certificate of deposit is also an instrument that you would receive when you do the oh, I'm getting a headache. Your will when you're doing your living will, right? If you do the course for your trust and setting up everything, the certificate of deposit is received after going through the second item on the will. Right? Certificate of deposit means an instrument. It's an instrument, which means what? It's a negotiable instrument. Certificate of deposit containing acknowledgement by the bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money. A certificate of deposit is a note of the bank. I can't make it much clearer than that. Okay, guys, let's go one more time. I'm going to show you guys a few things. All right, let's look into Lex Loci Contractus, right? Now, the law of a place where a contract was made in private international law. This law governs such a matter of the formal requirements of a contract and the capacity to incur the liability. The capacity to incur the liability as a party to a bill of exchange. As a party, what is a party? We just went over that. I hope it's clear. I don't want to keep talking about it. But the party to a bill of exchange, the negotiators, the two that are coming into the contract. Most other matters relating to contracts are governed by the proper law of a contract. We just went over the laws and the things that are applicable to you, making sure you understand that. The law of a place where a contract was made. It's a private international law. This law governs. It has the authority, which means it's governing. It governs such matters as the formal requirements of a contract. You are the person that is initiated, so you'll be able to govern the things over that particular contract. You are the one that is initiated. You are putting in what you feel to be applicable to you and what's fair to you, right? Okay. I want you guys to understand that this is coming from sections in law that I want to show you quite a few laws so you guys can understand that this is just not illusory, right? These are facts. Statutory public benefit limited liability company defined in the context of the certificate of formation and the limited liability company agreement. A statutory public benefit limited liability company. Who is that? Any company that is participating in selling to the public. Any company that has a contract with the government saying that we are fiduciaries, we are trustees, we are setting up these particular businesses to benefit the people, and the taxes will be paid based off of our service, but no, they take that and they make that turnaround on you. They give you the taxes. They create the fraudulent contract. It's illusory to you because you're so unaware. You don't have a mind to think. You are not unfeeble, because if you were feeble-minded, you would know how to contract. This is only in law. It doesn't mean you're stupid, doesn't mean you're dumb, doesn't mean you're ignorant. It just means in law, you don't have an understanding or an understanding of your rights as the people and where you stand. Now, a statutory public benefit limited liability company is a for-profit limited liability company that is formed under the subject to the requirements of this chapter that is intended to produce a public benefit. You mean that a statutory public benefit liability company is for a profit and it is for the benefit of the public? Wait a minute. How could it be for the benefit of the public if I am incurring a debt? Because I don't really incur that debt, right? Because that's not actually true, right? And to operate in a responsible, to operate in a responsible and sustainable manner. Do they operate in a sustainable manner and in a responsible manner? No, not if they're creating fraudulent contracts, not if they're omitting information like an H-9 rescission form, giving you your right to rescind the contract within 30 days and keeping your particular item because why? It's already been paid for. As long as you set that in stone, sending them the notifications and affidavits and letting them know that there will be judgment occurred because they are not fulfilling their fiduciary responsibility as a statutory public benefit liability company, which should be for the benefit of the public. And if you are going beyond that scope, you are now creating fraudulent contracts so that you can not only defraud me, but you can defraud the government, right? You can keep running the tax debt up, right? If people aren't aware of it, they'll take that and they'll apply that tax credit, and then now they will have you paying it. Instead of you understanding that it's already been paid and that they are the ones that owe the tax off of their percentage. It doesn't make sense to me, but they do it all the time. Now, and to operate in a responsible, sustainable manner, right? To that end, a statutory public benefit in a limited liability company shall be managed in a manner that balances the members' pecuniary interests. It should be used in what manner? In a manner that balances the members' pecuniary interests. What are the pecuniary interests? They'll tell you it's a finance charge. They'll tell you that you're going to have to pay this because your credit is X, Y, and Z. And because of that, you're going to owe this and you're going to have to pay this amount each month and da-da-da. But those are what? Pecuniary interests. And those things are what? They're supposed to be bounded to this contract so that we're both receiving the proper equity. Me with my 70%, you with your 30%. We don't have that in this contract. So let's get it right. The best interest of these materially affected by the limited liability company conduct and the public benefit of the public benefits set forth in this limited liability company agreement and in its certificate of formation. Not that certificate of formation. Yeah, the one that tells they got to be for the benefit of the public. Let me check with my chat real quick. I got so many windows open. I can't even see the chat while I'm talking. Hold on. Is that making sense? Okay. Is that making sense? Okay, I think it's making a little sense to you guys. Let's get it clear. Y'all know I'm about to get into it. This ain't it. It says that what? A statutory public benefit liability company, car dealership, real estate company, large business owners that you need the products and services from. These are all statutory public benefit liability companies, LLC. You see it? A statutory public benefit LLC. They are contracted to be here to help and assist you and operate for the people. Not deceiving the people, but why? These people go into contracts with the government because what? They're fraudulent and shit. If they're fraudulent, they can go into a contract with the government, then they can commit fraud and get away with it unless you accost them and take them to what? A proper court. And do what? Send these discharges to what? The Secretary of State. Because then what? You can also send the IRS statement so that they can now investigate this because they have committed fraud. They are stealing from the government and you. The government doesn't like that. They say that the government's against us, but only the fraudulent ones that don't have an understanding. Well, shit, if they can get over on you, who wouldn't get over on you? If you're letting them get over on you, if you don't want to take your fundamental mind and fund your mental so that you're able to apply it to your everyday life, then what? They're going to take advantage of that. Now, a statutory public benefit liability company shall state in its limited liability company agreement and in heading of its certificate of formation that it is a statutory public benefit. Do y'all understand that? Is that making sense? I don't really see too much going on right here if you guys don't understand that, right? And it shall set forth in its limited liability company agreement and its certificate of formation, one or more specific public benefits, public benefits, right? To be promoted by this limited liability company. The public benefit to be promoted by the LLC. In the event of any inconsistencies between the public benefit or the benefit to be promoted by the limited liability company as set forth in this limited liability company agreement and in its certificate of formation, what is that? The article of incorporation, certificate of participation that we just spoke of, right? Because these things are in their terms, right? They are binding themselves to be for public benefit, but they don't. Check this out. The limited liability company agreement shall control as among the members, the managers and other persons who are party to or otherwise bound by the limited liability agreement, a manager of the statutory public benefit limited liability company, or if there's no manager, there's any member of the statutory public benefit that is inaccurately set forth in its certificate of formation shall promptly amend the certificate of formation. Any provision in a limited liability company agreement or certificate of formation of a statutory public benefit limited liability company that is inconsistent with this subchapter shall not be effective to the extent of such inconsistency. Interesting, right? You guys get that, right? I don't know if you're doing that, but I'm going to move on. If you didn't, I don't know what to tell you. You may definitely not have a clear understanding of things, but I'm going to show you a few other things before we get out of here. What are finance charges when it comes to finance charges that are defined? Let me check with my chat real quick, just in case there's a question or anything. I am definitely. Yes. Oh, it's so clear, brother. When I tell you it's so clear, only agents do not want people to get this information. When I tell y'all that so many agents in this community that y'all been dealing with for years and y'all just love them, y'all go right ahead. These people promote Moors. They go against the law. They go against the grain because I'm damn sure the grain. I'm damn sure the grain around here. I don't care what nobody say. You can't even tell me no different because I already know my status. I know who I am. When you know who you are, there's no question in that. Let's start there. Let's keep moving, guys. Now, finance charge is defined, right? Except as otherwise provided in this section, the amount of a finance charge in connection with any consumer credit. Wait a minute, a consumer credit transaction? What is that? You mean to tell me as a consumer, there are credit transactions that I can occur? And yeah, it really is. Okay. This should be funny as hell to me. I swear, y'all just be trying to get through without cracking up sometimes. Because what people don't understand when it comes to this law is you have to study to show yourself approved. Study to show yourself approved. You can't be a person that sits back and listens to people, collects the information, and talk about it like you really understand it just because you're repeating something. You have to have that internally. Inside of you, you have to have a real clear understanding of things in order to make it applicable to you and for it to make sense, right? You cannot fund your mental with other people's teachings. You cannot fund your mental with things that are not effective if you don't know how to apply it. If you don't have a clarity in what true life is, like literally, I mean, come on. Let's keep it moving. It's a consumer credit transaction, and it shall be determined as the sum of all charges. Wait a minute, you mean the sum of all charges? The sum of all charges? A finance charge is the sum of all charges. Let me get to my chat real quick. I'm going to drop the link too. I would love some participating on people to understand what's going on. I want to know if y'all got questions, if y'all getting it. I'm going to drop the link just in case. Anybody want to come up? Come on up. Let's get to it. Let's get some clarity around here. Let's fund the mental around here. Y'all know I like to do that. Let's get the mental funded, which is the highest force of currency, having that mind in the proper state of frequency. Damn, everybody can't do it. Let's go, guys. We're going to get right back to it because it's going to be even clearer to you guys. Now, the sum of all charges. A finance charge is the sum of all charges payable directly or indirectly by the person to whom the credit is extended. Who extends the credit? You extend it. Who is the person? The company. The credit is extended to who? You. And imposed directly or indirectly by the creditor or as an incident to the extension of the credit, right? The finance charge does not include charges of a type payable in a comparable cash transaction. The finance charge shall not include fees and amounts that are imposed by third-party closing agents. Didn't we just go over that? We just had a clear understanding of that. And here it is confirming it for you right in the finance charges. The finance charge shall not include fees and amounts imposed by third-party closing agents. A third-party closing agent is a person that is coming to do what? Attach themselves to your contract. We just talked about this. The illusory promise. That finance charge that they're taxing you with, which is actually yours, which you should be creating a contract to say that, hey, I want a certain amount of equitability from these particular finance charges. You know, I'm going to give you 30%, 20%, and I'll take the 70 and 80% because it all really belongs to me. I don't mind giving you a percentage because what you are performing your fiduciary responsibilities as the trustee and a conservative of this limited liability public company. I don't even know if y'all getting this. Let's go. The type of payable in a comparable cash transaction. The finance charge shall not include fees and amounts imposed by the third-party agencies. Those third-party agencies attaching themselves so that now they can use your bond. They can cheat you. Including settlement agents, including attorneys, and escrow and title companies. If the creditor does not require the imposition of the charges or the services provided and does not retain the charges, examples of charges which are included in the finance charge include any of the following types of charges which are applicable. What are these charges? Interest, time price differential, and any amount payable under a point discount or other system. Service or carrying charge, loan fee, finder's fee, or simple or similar particular charge, fee for an investigation or credit report, premium or other charges for any guarantee or insurance protecting the creditor against the obligor's default or other credit loss. Borrower paid off mortgage broker fees, paid off mortgage broker fees, including fees paid directly to the broker or the lender for delivery to the broker, whether such fees are paid in cash or finance. If you're paying it in cash, it would be what? The sum of all charges, right? The financing would be the sum of all charges. So once I pay in cash, that debt note is an obligatory note. Just as efficient as a negotiable instrument, just as efficient as a bill of lading, just as efficient as a bill of exchange, right? I hope you guys understand that. I just don't know. Title 46. I'm going to get back to this because, yeah, maybe I'll finish out with that. Let me let you guys understand something when it comes to the Truth in Lending Act, right? Truth in Lending Act, Regulation Z. Have an understanding of this. Look this up, guys. Truth in Lending Act, Regulation Z. The Truth in Lending Act, TILA, of 1968 is a federal law that is designed to promote the informed use of consumer credit. Oh, shit. Not the informed use of consumer credit. You mean to tell me the federal law designed something and the Truth in Lending Act is proposed to promote the informed use of consumer credit? Let me check the chat because I don't know how y'all be if y'all be getting this. I really hate wasting my time, but I want to make sure y'all getting this. Do y'all get it? Do you get it? Do you get it? Do you get it? Put a 1 in the chat if you get it. Put a 1 in the chat if you get it. I want to see if y'all get it before we move on. Do you guys get it about the consumer credit? Is it clear? It's still not clear. Okay, nobody gets it. This is crazy. Nobody gets it. You guys need to do a lot of studying. Like, really. If y'all don't get it, I'm not going to even get into it because I'm going to go through a few other things. So this video is definitely for my members only, people that are taking classes. So they have indefinite information as well to refer to. I don't mind sharing with you guys, but yeah, it's just that simple. Okay. Federal law designed to promote the informed use of consumer credit. Lord, it requires disclosures about the terms and the cost of loans, disclosures about the terms and the cost of loans, just like what? The H-9 form. This is a part of that disclosure that has to be in your particular form, right? The H-9 form, I just showed you guys. This is a part of that. You have a rescission model form, the right to cancel a loan. This is what it's talking about. If that is not clear with you guys. Do you guys have a clarity of that, right? Now, saying this once again, going back into it, the cost of loans to standardize how the borrowing costs are calculated and disclosed. That's what they say the finance charges are too, right? TILA also gives consumers the right to cancel certain credit transactions that involve a lien on the consumer's principal dwelling. They have the right to cancel certain credit transactions with the H-9 form? Yes, of course they do. That involves a lien. What is a lien? A lien is saying that you owe them. You have a debt to them. They're putting a lien on your fictitious name saying that you owe the debt because you didn't endorse the instrument properly. That's only because you didn't know what to do. Right? Yeah. It regulates certain credit card transactions and practices and provides a means for fair and timely resolution of credit billing disputes, with the exception of certain high-cost mortgage loans. TILA does not regulate the charges that may be imposed for the consumer credit. Rather, it requires uniform or traditional disclosures of cost. It requires uniform. That means what? In order, strict and in order, defined, right? Or standardized disclosures, as I just showed you. That's a disclosure telling you have the right to terminate this contract of the costs and charges so that the consumers can shop. I can change my mind and decide, hey, this ain't what I want because you ain't being fair to me right now. I'll go somewhere else. Thank you so much. You guys can check that out. I told you many times about the Dodd-Frank Act, which is transferred to which transferred the Federal Reserve Board's rulemaking authority for TILA to the Consumer Financing Protection Bureau as of 2011. Oh man, do I want to get into this? No, I can't even get into the heavy stuff with you guys because it gets kind of frustrating for me. We're gonna get into a little bit of the maxims of law though. This is gonna give you a lot of information on the clarity of that, but I want to let me see. Maybe I should do this after. Do a little reading, give me a break, and then get into the other things. Yeah, I'll do that. All right, hold on. Let me see what page I'll start in. Da-da-da. Yeah, we'll start up here at the beginning. I'm definitely not going to go through the whole thing, but I want you guys to get a little understanding when it comes to maxims of law. Okay. All right. Let's start right here.
Content 1. Accidents and injury 10. Fictions 19. Possession 2. Benefits and privileges 11. Fraud and deceit 20. Property and land 3. Commerce 12. Yahweh and faith 21. Right and wrong 4.
Positive law.
Common sense 13. Governments and jurisdiction 22. Scriptural 5. Consent and contracts 14. Heirs 23. Servants and slaves 6. Court and pleas 15. Judges and judgment 24. Wisdom and knowledge 7. Court appearance 16. Law 25.
Let me speed
Witnesses and proof 8. Customs and usages 17. 17 marriage 26. Miscellaneous 9. Expressions and words 18. Officers 1. Accidents and injury A. An act of Yahweh does wrong to no one. B. The act of Yahweh does no injury, that is, no one is. C. The execution demand and then suit. L. C. No one is. He who derives a benefit. F.
Benefits and privileges.
He who enjoys the benefit. He who derives a benefit. Benefits and privileges. A.
Okay.
Favors from government often carry with them an enhanced measure of regulation. B. Anyone may renounce a law introduced for his own benefit. C. No one is obliged to accept a benefit against his
renouncing
consent.
Law.
D. He who receives the benefit should also bear the disadvantage. E. He who derives a benefit from a thing ought to feel the disadvantages attending it. F. He who enjoys the benefit ought also to bear the burden. G. He who enjoys the advantage of a right takes the accompanying disadvantage. H. A privilege is, as it were, a private law. I. A privilege is a personal benefit and dies with the person. J. One who avails himself of the benefits conferred by statute cannot deny its validity. K. What I approve I do not reject.
Getting to get the commerce.
I cannot approve and reject at the same time. I cannot take the benefit of an instrument, and at the same time repudiate it. L. He who does any benefit to another for me is considered as doing it to me. 3 commerce A. Caveat emptor, let the buyer beware. B. Let the purchaser beware. C. Let the seller beware. D. The payment of the price stands in the place of a sale. E. The payment of the price of a thing is held as a purchase. F. Goods are worth as much as they can be sold for. G. Mere recommendation of an article does not bind the vendor of it. H. It is settled that there is to be considered the home of each one of us where he may have his habitation and account books, and where he has made an establishment of his business. I. No rule of law protects a buyer who willfully closes his ears to information, or refuses to make inquiry when circumstances of grave suspicion imperatively demand it.
What that shit say? What do it say? This is like one of the most important statements right now. No rule of law protects a buyer who willfully closes his ears to information, who willfully closes his ears to information, or who refuses to make the inquiry when the circumstances of grave suspicion imperatively demand it. I don't even know if y'all get that, but I ain't gonna even break it down, but let's go. Damn, I knew it was gonna do that.
F. He who enjoys H. G.
Yeah, I don't get it.
No rule of law protects a buyer who willfully closes his ears to information, or refuses to make inquiry when circumstances of grave suspicion
you shall
imperatively
find, knocking the
demand
doors open.
J. Let everyone employ himself in what he knows. K. He at whose risk a thing is done, should receive the profits arising from it. L. Usury is odious in law. Exodus 22:25. Leviticus
Usury,
20.
if you didn't see the video I did on usury and cash, make sure you go watch that and you'll have a clear understanding of usury in the cash system.
5:36-37, Nehemiah 5:7, Proverbs 28:8, Ezekiel 18:8, 13, 22:12-4. Common sense A. When you doubt, do not act.
Common sense.
It is a fault to meddle with what does not belong to or does not concern you. C. Many men know many things, no one knows everything. D. One is not present unless he understands. E. It avails little to know what ought to be done, if you do not know how it is to be done.
Period.
F. He who questions well, learns well.
Question and learn.
Whatever is done in excess is prohibited by law. H. No one is bound to give information about things he is ignorant of, but everyone is bound to know that which he gives information about.
Period.
I. No man is bound to have foreknowledge of a divine or a future event. J. No one is bound to arm his adversary. 5. Consent and contracts.
Consent and contracts.
Consent makes the law. A contract is a law between the parties.
Once you consent, unbeknownst to you, even if you don't understand, there is no excuse for ignorance of the law. If you don't take your time to understand, have a clear, concise understanding of what's going on, whose fault is that? It's nobody's fault but yours. There's no excuse for ignorance of the law. Consent, your consent. Once you sign and you give them the authority to create that contract and put their terms on there, you're not negotiating anything. You're not endorsing it. You're not reserving your rights on this contract. That is pure ignorance of the law. Consent makes that the law. So now you have contracted and given your consent for them to dupe you, right? To abuse you, use you, so on and so forth. It says that a contract is law between the parties. Once you create the contract and allow them to create all the terms, you no longer negotiate anything. You do not reserve your rights. It is bound by law. Now, if you have the correct sense, you can go back and you can obtain your equity on that. You can prove a fraudulent contract because it's what omitted with certain things that are required by law, that are required by the Truth in Lending Act, that are required for consumer transactions. If those things aren't done, you can then go back and enforce the equity. Right? Let's go.
Can acquire force only by consent. B. Consent makes the law, the terms of a contract, lawful in its purpose, constitute the law as between the parties. C. To him consenting no injury is done. D. He who consents cannot receive an injury. E. Consent removes or obviates a mistake. F. He who mistakes is not considered as consenting. G. Every consent involves a submission, but a mere submission does not necessarily involve consent.
Because
H.
What? It could be
a contract
fraudulent.
founded on a base and unlawful consideration, or against good morals, is null. I. One who wills a thing to be or to be done cannot complain of that thing as an injury. J. The agreement of the parties makes the law of the contract. K. The contract makes the law. L. Agreements give the law to the contract. M. The agreement of the parties overcomes or prevails against the law. N. Advice, unless fraudulent, does not create an obligation. O. No action arises out of an immoral consideration.
Unless fraudulent.
No action arises on an immoral contract. Q. In the agreements of the contracting parties, the rule is to regard the intention rather than the words. R. The right of survivorship does not exist among merchants for the benefit of commerce. S. When two persons are liable on a joint obligation, if one makes default the other must bear the whole. T. You ought to know with whom you deal. U. He who contracts, knows, or ought to know, the quality of the person with whom he contracts, otherwise he is not excusable. V. He who approves cannot reject. W. If anything is due to a corporation, it is not due to the individual members of it, nor do the members individually owe what the corporation owes. X. Agreement takes the place of the law, the express understanding of parties supersedes such understanding as the law would imply. Y. Manner and agreement overrule the law. Z. The essence of a contract being assent, there is no contract where assent is wanting. Court and pleas. A. There can be no plea of that thing of which the dissolution is sought. A false plea is the basest of all things. B. There can be no plea against an action which entirely destroys the plea. C. He who does not deny, admits. A well-known rule of pleading. D. No one is believed in court but upon his oath. E. An infamous person is repelled or prevented from taking an oath. F. In law none is credited unless he is sworn. All the facts must, when established by witnesses, be under oath or affirmation.
It says what? In law none is credited unless he is sworn, taking it to court, proving their equity, showing that there was a fraudulent contract and I need to receive my equity. Let me move this. Actually, I'm trying to get to another page here. Show you guys a couple other things. Is it this one? We got about 10 more minutes. Dang, I don't want to get too far. Just want to show a couple more things. Hold on, guys. I want you guys to have a clear understanding of quite a few things before we get out of here. Hold on one second. Let's close my page, really. All right, there we go. Oh, this thing is doing the most. Hold on a second. Okay. Oh no, I don't think I'm gonna show you that. Hold on. I don't want to get into too much of that. Let's get into this notice of dishonor. When it comes to UCC, subsection 3-504, excuse presentment and the notice of dishonor. Presentment for payment or acceptance of an instrument. Presentment for payment or acceptance of an instrument is excused if I, the person entitled to present the instrument cannot with reasonable diligence make presentment. The maker or acceptor of the repudiated an obligation to pay the instrument or is dead or in insolvent proceedings by the term of the instrument that is presented. It's not necessary to enforce the obligation of the endorsers or the drawer or the endorser whose obligation is being enforced has waived presentment, or otherwise has no reason to expect or right to require that the instrument be paid or accepted, or the drawer instructed the drawee not to pay or accept the draft, or the drawee was not obligated to the drawer to pay the draft. You're the obligee, right? Notice B, notice of dishonor. Notice of dishonor is excused if by the terms of the instrument, notice of dishonor is not necessary to enforce the obligation of a party to pay the instrument, or the party whose obligation is being enforced waive notice of dishonor. A waiver of presentment is also a notice of dishonor waiver. Right? Delay in giving notice of dishonor is excused in a delay which causes by circumstances beyond the control of the person giving the notice, and the person giving the notice exercise the reasonable diligence after the cause of the delay cease to operate. What is evidence of that dishonor? Let's check that out. Evidence of the dishonor. The following are admissible as evidence in creating a presumption of dishonor and of the notice of dishonor and relief that is stated. 1, a document regular in form as provided in subsection B, which purports to be a protest, a purported stamp or a writing of the drawee, payer bank, or presentment or presenting bank, or an accompanying or an instrument that states that the acceptance, an instrument stating the acceptance or the payment has been refused unless reasonable for the refusal are stated and the reasons are not consistent with dishonor. A book or record of the drawee, payer, bank, or collecting bank, kept in the usual course of business, which shows the dishonor, even if there is no evidence of who made the entry. A protest is a certificate of dishonor made by the United States consular or vice consular or a notary public or other person that is authorized to administer oaths by the law to place where the dishonor occurs. It may be made upon the information satisfactory to that person. The protest must identify the instrument. The protester must identify the instrument and certify that the presentment, presenting it correctly, has been made, which will be what? The Secretary of State, because you have to do what? Send that notice of dishonor, that notice of intent, that affidavit to what? The Secretary of State. If not made, the reason why it was not made and the instrument has been dishonored by non-acceptance or non-payment, the protest may also be certified that the notice of dishonor has been given to some of all parties. Because what? You're going to send that notice to each one of those parties. The ones that have committed the fraud, the court system, and you're going to have it notarized, right? You're going to make sure that you notarize. ORS 73.0504, excuse presentment and notice of the dishonor, right? Presentment for the payment or the acceptance of the acceptance of an instrument is excused if what? The person entitled to present the instrument cannot with reasonable diligence make the presentment, the maker or the acceptance as a repudiated and the obligation to pay the instrument, or is dead or in insolvency proceedings by the terms of the instrument presented and not necessary to enforce the obligation. An endorser of the drawee, the drawer, or an endorser whose obligation is being forced was waived in the presentment or the otherwise has not reason to expect or right to require that the instrument be paid or accepted. Validating or confirming once again. All right, hold on a second. We got a few more minutes. I'm going to show you guys one or two more things, and we will be out. Make sure you guys come tune in later. I will be doing an interview with a lady that was a part of a cult, and what is going on in these cult communities, these Hebrew Israelites, these wives, they're abusing them. It's so much going on. Oh my gosh, I can't wait to do this story because I am just teed off about it. This, I'm not going to get into that. Hold on, guys. I have some things pulled up from my class. I'm going to show you guys a couple of things. Okay. 18, Title 18. We're going to look at Title 18, U.S. Code, subsection 8, obligation or other security of the United States define. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, bills, United States notes, fiat, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposits, certificates of deposits. Then I just go over that with you. Bills, checks, or drafts for money, drawn by or upon the authorized officers, the officers of the United States, which are who? Those people that are the public interest of the public trust, which are the fiduciaries. These are authorized officers of the United States. Stamps and other representatives of values of whatever denomination that is issued under any act of Congress and canceled the United States stamps. Y'all don't understand that. They're talking about your negotiable instruments once again. Need me to read it again? The term obligation or other security of the United States. Let me show you guys, actually. Let's show you guys real quick. Obligation or other security of the United States. The term obligation or other security of the United States includes all bonds. It includes all bonds, certificates of indebtedness. Do you guys get this? Like, is this shit clear or not? Like, y'all like, this chat's so dead. I know there's only a few people in here because they don't really understand it. But those that understand, those who have ears to hear, eyes to see, and have an understanding, do you get this? Includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, certificates, silver certificates, fractional notes, certificates of deposits, bills, checks, or drafts of money, right? Drawn by or upon the authorized officers of the United States, the authorized officers of those United States. All these people that are LLCs, the limited liability companies. It just told you that. We just read that earlier, didn't we? Okay. Okay, we just read that. So you guys do have an obligation to understand it. Now, coming to, hold on. I'm going to show you guys a true credit application, right? And we're going to be out here after this, once I go over this with you guys, just so you can have the clarity and see what, what a clear, open end unsecured credit, an open-end unsecured credit. You guys might not get that, but I'm about to show you. Credit application, important. Read these directions before completing the application. If you are applying for an individual account of your own name and are relying on your own income or assets and not the income or assets of another person, if you are applying for a joint account, we intend to apply for the joint account. It would be your application and the other. If you are applying for an individual account, but are relying on income from alimony, so on and so forth, so you can make sure that you assure your income for the particular credit approval, right? Let me see. Information regarding the application, so on and so forth. You'll be able to put all child support, Social Security, all these things are listed as income. Social, what do you call it, DSS or Department of Social Services. These particular people, section be informed regarding joint application. You put their information there. These are the types of contracts you should be going into a dealership with, making sure you're putting the description of the assets. What are the assets? Cash value, life insurance, real estate, marketing, sureties, right? What are marketing sureties? That could be a negotiable instrument. Any particular negotiable instrument that you would create for this, right? I would put other. And I would list my negotiable instrument. You might pay with stamps. You might pay with a credit application. You might pay with a secured credit, so on and so forth. You can put everything, outstanding debts, everything that you would put on there, so on and so forth. You should have one of these printed out and filled out before going to any dealership or before any particular transaction. That way you are able to put the terms on there. You're able to apply the terms as to what you want them to be, right? It's up to you to make sure that it is fair, right? It's up to you to understand what's going on. Oh, I wanted to do one more thing. I said that was it. Okay, I'm one more thing before we out of here. UCC, subsection 5-108, when it comes to the issuer's rights and obligations, the issuer's rights, and your obligations, right? Except as otherwise provided in section 5-109, an issuer shall honor a presentment. An issuer shall honor a presentment that, as determined by the standard practice referred to in subsection E, appears on its face strictly to comply with the terms and the conditions of the letter of credit. A letter of credit. That's what I was just showing you on that application. You would submit what? A letter of credit. An affidavit that go along with that particular application once you have filled it out with all of your terms on it. Except as otherwise provided in section 5-113, and unless otherwise agreed with the applicant, an issuer shall dishonor a presentment that does not appear so to comply. B, an issuer has a reasonable time. An issuer has a reasonable time after presentation, but not beyond the end of the 7th business day of the issuer after the date of its receipt of the documents. 1, to honor. 2, if the letter of credit provides for honor to be completed, I should show you guys a sample letter of credit. Let me see, I got a few minutes. Let me see, maybe not, maybe next time. Letter of credit provides for honor to be completed more than 7 business days after the presentation to accept the draft, or to incur a deferred obligation, or 3, to give notice to the presenter of discrepancies in the presentation. So now you will be able to note those discrepancies as fraud and dishonor, of that contract, canceling that contract, and actually filing suit. Okay, hold on. Now, an issuer shall observe standard practices of financial institutions that regularly issue letters of credit. Determination of the issuer's observance of the standard practice is a matter of interpretation for the court. The court shall offer the parties a reasonable opportunity to present evidence of the standard practice. You can present your evidence to acquire your equity because of what? Fraudulent contract. All these contracts are fraudulent. No one goes into it with the truth unless you're able to, make sure that you establish it in the beginning. An issuer is not responsible for 1, the performance or the non-performance of an underlying contract, arrangement, or transaction. 2, an act or omission of others. Or 3, observation or knowledge of the usage of a particular trade that other than the standard practice that is referred to in subsection E. E like Edward. G, if an undertaking if an undertaking constituting a letter of credit under section 5-102A, like Apple 10, contains non-documentary conditions, an issuer shall disregard and non-documentary conditions and treat them as if they were not stated. An issuer that has dishonored a presentation shall return the documents or hold them at the disposal and send advice to the effect to the presenter who's presenting the bill, saying that I owe this. An issuer that has honored a presentation or permitted or required by this article. 1, is entitled to be reimbursed by the applicant. Is entitled to be reimbursed by the applicant in immediately available funds, not later than the date of its payment of funds. Take the documents free of claims as the beneficiary or presenter. You are the beneficiary or the presenter. Honoring the presentment would be up to them when you are presenting. It's precluded that that asserting a right of recourse of a draft under section 3-414 and 3-415. 4, except as otherwise provided in section 5-110 and 5-117, is precluded from the restitution of money. Is precluded from the restitution of money paid or other value given by the mistake, to the extent that the mistake concerns discrepancies in the documents or the tender which are apparent on the face of the presentment. And 5 is discharged is what discharge 5 is what discharged to the extent of its performance under the letter of credit, unless the issuer honored the presentation in which a required signature of the beneficiary is forged. Oh, I just read a case like that. The lady said that they duplicated using a carbon copy of her signature and created another document. Not only does it show that she had purchased one vehicle, but 2. Let me see. Okay, I'm at my hour and 30 minutes here. This is about much I can do right now. I'm going to be coming back later. As I said, make sure you guys are tuning in. We will be interviewing this lady that was a part of this cult. And this is Hebrew is, I don't know what kind of nation this is, but we'll definitely be going over that this evening. Make sure you guys are tuning in around 7 o'clock. I will put the live up shortly, just so you guys are informed of it. You can set the reminder. This is very intense. This woman has been a part of this cult. She's going to explain how she became a part of it. This man's like 30 years older than her. There are multiple different wives under this Hebrew nation. It's just completely ludicrous to me. I was astounded when I heard the story. So I will definitely have her on this evening, because I want you guys to understand how these people are literally manipulating people in our community. Like literally. Peace, love, and bliss to all. Make sure you guys, if you are watching the stream and you want to make sure you didn't miss anything, please rewind it back shortly. It will be under our members only tab. I appreciate anyone that tuned in. Peace, love, and bliss, and I am out.